and that is the question of whether 13 jurors were improperly discharged in violation of Witherspoon versus Illinois and Wainwright versus Witt. Excuse me. Second, Your Honors, I'd like to talk a little bit about two of the rulings made in connection with the demonstration, the boat demonstration experiments. In particular, I would like to talk about the court's ruling that Mr. Peterson's lawyer could, in fact, have access to Mr. Peterson's boat to do a demonstration, but only if the prosecutor was present for that demonstration. And I'd like to talk about the court's subsequent ruling that the jury's own boat demonstration was not an improper jury experiment. And finally, time permitting, since although it rarely does, I'm hoping it will, I'd like to talk a little bit about the venue issue, which is referenced in the court's focus letters. So let me start with the Witherspoon-Witt issue. As I noted above, it involves, at least in the briefing, I'm sure the court's familiar with it, the claim is that 13 jurors were improperly discharged in violation of Witherspoon and Witt. The good news is that I'm not going to take us all through the 13 jurors today. I thought I would focus on three of the jurors. In particular, jurors 6960, 8340, and 4841. But before I get into the nitty-gritty of those three jurors, Your Honors, I'd like to start with 3 points that the state and my colleague from the Attorney General's office and I agree on, because I think really these 3 points of agreement control this issue. And the first point we agree on is the standard of review. This court's review, the state concedes, is de novo, and that's important. This is not a case where the court voir dire questioned the jurors and discharged them based on an assessment of their demeanor, their tone of voice, their body posture. It was a case where the trial court discharged all 13 jurors based solely on the juror questionnaires. And we now know, and the state concedes, that in fact, review is de novo in that situation. The second point we agree on, and that I think controls this issue, is that there's a substantive standard of review that we agree on. And that is the court in a number of similar cases has held that where a trial court discharges a juror based solely on juror questionnaires, the question is whether those juror questionnaires, quote, leave no doubt, end quote, and, quote, make clear, end quote, that the juror would in fact not follow the law and refuse to set aside his or her views with respect to consideration of penalty. And the third point we agree on, Your Honors, is that because this is de novo review, and because the state is defending the discharges below and advocating for those discharges here today, they have the burden of showing that this substantive standard, this leave no doubt standard, has been satisfied. So with that in mind, with those 3 points in mind, let's take a look, starting with juror 6960. This juror said that she was opposed to the death penalty. Opposed, not strongly opposed, opposed. They had 3 options: weakly opposed, opposed, and strongly opposed. This juror was simply opposed. In answer to question 115, however, she said her views would not preclude her from imposing death. And the court discharged this juror saying, quote, I'm going to exclude 6960 for cause because that juror is opposed to the death penalty without reservation. The state defends that ruling and argues that it has carried its burden of showing that there's, quote, no doubt, and that the juror questionnaire made clear this juror would not follow the law for 2 reasons. They focus on 2 additional answers in the questionnaire. One, they focus on the fact that this juror, when asked about the death penalty, said, quote, I wish it was not something we needed, end quote. Second, when asked about her opinions on life without parole, she said, quote, it's good in some cases, end quote. And the state argues that these answers show that this juror leaves no doubt that this juror would refuse to follow the law. And I want to make an additional comment on each of these defenses. The juror's statement that she wished it were not something we needed. On its face, of course, this says nothing about whether the juror will follow the law or her own views. And in fact, to the extent the juror questionnaire covers that subject, it's important to note that there are 5 separate questions in that questionnaire that ask jurors if you will follow the law as instructed by the court. Questions 79 and 80, question 89, question 97, and question 100. They all ask the juror in a variety of different areas, will you follow the court's instructions? One talks about circumstantial evidence. One talks about the presumption of innocence. One talks about deciding the case based solely on the evidence in court. As to each of those 5 questions, juror 6960 said yes, she would follow the court's instructions. So there is nothing looking at juror a question, Juror 69660's questionnaire that says, that leaves no doubt she will not follow the law. And in fact, her comment that she wished it were something that wasn't needed, to me says the exact opposite. I may disagree with her on this, but to me it says she recognized, at least in her view, that the death penalty was something that was needed and that she would apply. And I think that's reinforced by the second fact that the state relies on. This juror's statement that as to life without parole, she felt it was, quote, good in some cases, end quote. I believe the state's reliance on this piece of evidence actually turns Witherspoon squarely on its head. Witherspoon was designed to permit the state to discharge jurors who would not follow the law. When this juror expresses her view that life without parole is good in some cases, she is expressing the identical view expressed by the United States Supreme Court in its post-Gregg capital jurisprudence. There are no mandatory death penalties. In a state like California, jurors are presented with aggravating evidence, and they're presented with mitigating evidence. And they're asked to make a choice. Sometimes jurors choose death. Sometimes they choose life without parole. Put another way, in the terms that Juror 6960 used, life without parole is good in some cases. The state is seeking to discharge this juror not because she would not follow the law, but because she would. This is not a discharge that's permitted under Witherspoon. Let me go then to the next juror, Juror 8340. This juror was strongly opposed to the death penalty as opposed to simply opposed in the prior juror. And this juror also said, however, that her views would not preclude her from imposing death. And the trial court discharged this juror because, quote, the juror is excused because the juror is opposed to the death penalty on religious grounds. And that's true. She did state the source of her opposition was religious grounds. And in fact, that's the primary reason the state defends this discharge. There are two reasons, but the primary reason is that the source of her opposition was religious. And the second point the state makes is that she preferred life without parole. She said she preferred it in her questionnaire. And I want to make an additional comment on each of these. The state's focus on the source of this juror's opposition to the death penalty completely misapprehends Witherspoon. And they do this, one of the reasons this juror is useful is because the state focuses on source with a number of the 13 jurors I've identified. Witherspoon does not say you can discharge depending on the source. Regardless of the source, the Witherspoon inquiry focuses on whether the juror can set aside the views, whether the views are religious-based, philosophically based, morally based, financially based. The Witherspoon inquiry is about setting those views aside, not the source. And we don't have to look any further than I believe this court's decisions in Woodruff and Buenrostro and Zaragoza to know that the fact that a juror has a religious basis for their opposition is not in and of itself sufficient to discharge them based solely on the juror questionnaire. That leaves the state with one other additional factor about this juror they say that justify the discharge, and that is that she preferred life without parole. And let me be frank with the court and concede this, that every juror who is opposed to the death penalty will prefer life without parole. It is the flip side of the same coin. After all, if you're opposed to the death penalty and you're asked what your views are of the death penalty or life without parole, you're going to prefer life without parole. That's what being against the death penalty is all about. It's the flip side of the same coin. Saying that you cannot discharge someone for opposition to the death penalty, but you can discharge them because they prefer life without parole, it's a shell game. And in fact, we know from this court's decisions in People v. Leon and People v. Covarrubias that in fact, the fact that you may prefer life without parole is not sufficient based on juror questionnaires to justify a discharge. So let me turn then to the third juror at issue here, Juror 4841. And she's useful for a different reason because she points out in the state's defense to her, there are some common themes with some of the other jurors, so I think it's useful to talk about 4841 as well. She was strongly opposed to the death penalty. She said her views would not preclude her from imposing death. And the court discharged her because the answer on page 19109 and that's the jury questionnaire that the judge is referring to. Would you please rate your attitude toward the death penalty? Strongly opposed, so this juror also would not qualify. And the state defends this juror primarily on the grounds that this juror did not equivocate. And that's true. And the state defends a number of the jurors, a number of the 13, on the grounds that they weren't ambiguous or they didn't equivocate. And that's true, but again, it misapprehends the Witherspoon inquiry. The inquiry is not into whether someone equivocates or is ambiguous. The Witherspoon inquiry requires a much simpler question. Regardless of whether you equivocate and regardless of whether you're ambiguous, can you set your views aside? And there's nothing in this juror's questionnaire that suggests he could not set her views aside. More importantly, there's nothing in this questionnaire that leaves no doubt that she would refuse to set her views aside. So, those three jurors, I think, point to some of the problems with the state's overall position in the Witherspoon. Let me talk for just a moment about potential remedies.
Mr. Gardner, before you talk about potential remedies, could I ask you, I know that you have focused on these 13 jurors in your briefing. The President of the United States Supreme Court and this court, of course, say that the erroneous dismissal of a single juror constitutes constitutional error. But I'm wondering about the scale of this set of dismissals in the context of this particular jury selection process. Although you focused on the 13 jurors, just looking through the record, there appear to be a number of times in which the trial judge dismissed a juror by reference to the questionnaire answer concerning general attitudes toward the death penalty. So it seems to be some sense that indicating opposition or strong opposition to the death penalty in response to question number 109, there seemed to be an understanding that that was a basis for cause dismissal, even for jurors other than the 13 that you've specifically focused on in your briefing. Is that correct? Am I reading the record correctly?
I think you are reading the record correctly. Some of those are not focused on in the briefing, Your Honor, because what was happening was some of the jurors would say, for example, I believe defendant is guilty, but I'm opposed to the death penalty. And what defense counsel would do often, Your Honor, is he would stipulate to the discharge of that juror premised on their views as to guilt, but object on the basis of their views as to penalty. It's not something I've seen before. It's a rather unusual stipulation and submission. But Your Honor is correct. I have focused on 13 jurors where the court has made the statement, if you're opposed, you can't sit, but there are others. So let me turn to a minute to remedy. Again, I'll start with a point of agreement. The court agrees, the Attorney General agrees that under current law, at a minimum, the death penalty has to be retried. And that's fine as far as it goes. I have argued that, in fact, the guilt phase should also be reversed. Now, the state disagrees with me. I understand why. And let me state that there's been a lot of water under this bridge. I recognize that in many cases, this court has held that improper discharge of jurors under Witherspoon requires reversal only of the penalty phase. So it seems to me that the burden fairly falls upon me to persuade this court of 2 points. First, I need to persuade this court that this is an open question. It's not foreclosed by precedent. And second, it seems to me that the burden is fairly placed on me to show the court that in addition to not being foreclosed by precedent, that this argument is correct on the merits. Let me see if I can do those relatively quickly now. In terms of precedent, I don't think there's going to be any disagreement that Witherspoon doesn't resolve this under the Eighth Amendment. Witherspoon was a Sixth Amendment case. Indeed, it couldn't have been an Eighth Amendment case because it was decided in 1968, 4 years before the court began its march toward employing the Eighth Amendment in assessing capital jurisprudence processes, infirmary. So Witherspoon isn't the Eighth Amendment barrier. The state, to its credit, recognizes that and says, well, this court has held that proper death qualification doesn't violate the Eighth Amendment. And the state is right. In cases from Hovey on down, and the U.S. Supreme Court has also reached this decision in Lockhart. But this is not proper death qualification, and that's important for 2 reasons. One, proper death qualification, and Hovey has an interesting opinion on this, and they use interesting language. Proper death qualification at least leaves the jury balanced. I think Hovey called it a neutral jury. Because after all, you may be taking off people that oppose the death penalty and won't consider death as an option. But you're also taking off the jury people who are in favor of the death penalty and won't consider life as an option. So the jury remains balanced. What happened here was a systematic exclusion of people who were opposed to the death penalty but would consider death as an option. Now, you weren't doing improper life qualifying under Morgan. The trial court didn't discharge people who were in favor of the death penalty but would consider life. That would at least leave a balanced jury of people who were indifferent, as I think the language, or neutral on the death penalty. So what we have here is something very different. We don't have a disqualification scheme that results in a balanced jury. We have a disqualification scheme that results in an imbalanced jury. And in contrast to death qualification, there's no need to do that to obtain a unitary jury. We already had one. So I believe that the Eighth Amendment cases that the state properly relies on don't resolve this issue. That doesn't mean I'm right, but it means that it's not foreclosed by precedent. So let me talk a little bit about why I believe that there's a need to reverse the guilt phase as well. And it's a relatively simple Eighth Amendment argument that depends on two principles. The first is that effective group deliberation is essential to reach a reliable guilt phase verdict. There's not much dispute about that. The second is that in a series of cases, the United States Supreme Court has made clear that the Eighth Amendment does not permit procedures which undercut reliability. Now, before I put these two together, I want to concede something. The defendant is not entitled to a jury of 12 people that are all skeptical about the death penalty and that may harbor a pro-defense bias and may harbor an anti-prosecution bias. But by the same token, neither is the prosecution entitled to a jury of 12 people that think the death penalty swell and that harbor a pro-prosecution bias and an anti-defense bias. Reliability is best served when both groups are on the jury. Then there's the give and take that leads to a reliable verdict. And what happened here was the systematic exclusion of those jurors who were opposed to the death penalty but could consider death. And that removes a voice, a perspective from jury deliberations that I believe is essential to a reliable result. That's why I believe it's not foreclosed by precedent, and that's why I believe there is a Eighth Amendment violation as to the guilt phase. If there's no questions on the Witherspoon issue, I'll move to the second set of issues involving the boat demonstration experiments. And the first ruling that I'd like to talk about is the court's ruling that when defense counsel asked for the boat so he could do a demonstration as to whether it would capsize, the court hinged the release of that boat on the presence of the prosecutor at any demonstration that the defense performed. And the state defends that ruling. The state defends that ruling and says it's appropriate because it was necessary and to allow the prosecutor to meaningfully rebut and meaningfully confront any demonstration that the defense offered. And my point is a very simple one. As defense counsel pointed out at trial, it would have been a heck of a lot easier for defense counsel to meaningfully confront and meaningfully rebut the demonstrations that the prosecution used at this trial if he, the defense counsel, had been present when those demonstrations were performed. And I will go further, and I dare say it would be a heck of a lot easier for any defense lawyer in any criminal trial in this state to meaningfully rebut a prosecution's demonstration if he's present, he or she are present at the demonstration. Just like I will concede, it would be a heck of a lot easier for every prosecutor to meaningfully rebut and meaningfully confront a defense demonstration if the prosecutors are there for that demonstration. But that is not how our adversary system has ever worked. Alford versus Superior Court, this court was quite clear. The right to effective assistance of counsel includes the right to investigate your case in confidence. There is an exception to that rule, of course, and that exception is when there's for example, there's a biologic sample and testing will destroy it. At that point, it's perfectly appropriate for the court to order that testing be joined. But short of that situation, defense counsel had every right to do this investigation in confidence, and the court's ruling was a patent violation of the Sixth Amendment right to effective assistance of counsel. If the court has no questions on that issue, then let me move to the issue involving the jury experiment. The facts are pretty much not disputed. What happened was on the third day of deliberations, excuse me for a sec. On the third day of deliberations, jurors asked to see the boat. There was no objection, and the jurors were permitted to see the boat. And what happened then was that several jurors, at least two, defense counsel says, the prosecutor says two, got in the boat and they rocked it back and forth. They performed their own boat stability demonstration. Defense counsel objected and placed on the record his objections, and the court ultimately ruled that this was not an improper demonstration. Now, we agree on the question, colleague from the Attorney General's office and I, we agree on the appropriate question. The appropriate question is whether this experiment was, quote, within the lines of offered evidence, end quote. The state says it was, I say it isn't. Here's in a nutshell why I believe it isn't. And that's this. There was an inference that jurors were seeking to draw. They knew that this offense occurred in the open water, under the state's theory, the body was tossed off the boat in the open water. The jury was well aware that stability in a garage on a trailer was not the same as stability in the open water. They were trying to draw an inference from the stability on a trailer in the garage to what stability would be like in the open ocean. And that inference, simply put, was not within the lines of offered evidence. And that's immediately why defense counsel objected and said they've taken new evidence. There's a problem here. And ultimately the court said, no, this isn't an improper jury experiment. I believe it was an improper jury experiment precisely because it was not within the lines of offered evidence. Moving on then to venue. And let me just take a moment. The briefing discusses both the presumed prejudice and the actual prejudice elements or strands of the Supreme Court's jurisprudence. And the state and I, once again, there's a point we can agree on. We agree that the presumed prejudice test is reserved for extreme cases. That much we agree on. The state says this is not an extreme case. And my position in a nutshell was if this isn't an extreme case, then what is? Let's take a look. Extreme cases are based, the question of whether something's extreme depends on the nature and extent of publicity. And simply put, if this publicity isn't enough, I don't know that the presumed prejudice test still exists. Here's why. Let's take a look at the extent of this publicity and the nature. Again, there isn't much dispute. The state concedes it was pervasive, the amount of publicity, and it was. When the veneer was questioned, 100% of the veneer had heard of Mr. Peterson. 97 or 97.5% of the veneer had been exposed to the publicity. Now, that alone does not call for a presumption of prejudice. After all, if the publicity is balanced, if it's not negative, then there's no reason to presume prejudice. So let's take a look at whether it was adverse or not. We really don't have to draw any subjective judgments on this, because jurors were asked, having been exposed to this publicity, can you keep an open mind? How many of you have formed an opinion as to guilt or innocence? And nearly 50% of the jurors questioned in court who were filling out questionnaires said they had already reached an opinion as to guilt or innocence. Now keep in mind, this is not a telephone survey. This is people who are come to the courthouse and they are faced with the solemnity of court proceedings. And they, like all American citizens, know that their role is to set aside what they've heard and decide this case and be fair jurists about it. Notwithstanding that knowledge and notwithstanding the solemnity of the proceedings, nearly 50% of those jurors said they had already reached a decision before hearing a single witness. Now, even that doesn't necessarily justify a presumption of correctness, a presumption of prejudice, because maybe the press was balanced and maybe 50% of them thought he was innocent and the other 50% thought he was guilty. In fact, when we look at the data, we see that of the nearly 50% that had reached a decision, 98.5% thought he was guilty and 6 jurors thought he was innocent out of the 1,000 that had completed questionnaires at the time the change of venue motion was raised. So there's really no doubt about the pervasive nature. There's no doubt it was adverse. And there's really no doubt about whether it was influencing jurors. It plainly was.
Counsel, in some ways, every one of these cases is distinctive, but if you had to cite the case that has been decided that you think is most similar and helpful to your position on this issue, what would it be?
If I can, Your Honor, modify the question, let me cite two. Let me cite this court's decision in People versus Williams, and let me cite Rideau versus Louisiana. And let me start with People versus Williams. People versus Williams was a case where there was publicity pre-trial, and the court had to go through an extensive voir dire. They actually had to question 116 jurors, by gosh. 116 jurors to get a jury. Of that 116 jurors, 52% had heard of the defendant. The other 48% had never heard of him. Of that 116 jurors, 10 said they had reached a decision and they would not set their views aside, 8%. Contrast that with this case. 100% had heard of Mr. Peterson. 97% were exposed to the publicity. Nearly half had reached a decision, and of that, 98% thought he was guilty. And this is a figure we hadn't yet talked about. Half of that group, over half, said they would refuse to set aside their view. So a much greater percentage in this case than in People versus Williams. I think that's a really useful case for purposes of comparison as to whether a presumption of prejudice should apply. Rideau versus Louisiana is also an interesting case. That was the case, of course, where defendant's confession was broadcast on television 3 times prior to trial. And the Supreme Court held that a presumption of prejudice applied in that case. There was no need to look at the record of voir dire to see if a fair jury could be impaneled, because that was necessary. A presumption was necessary. And I think that's a useful case here. Now, it's true the state points out, well, this case didn't involve a confession. That's true, but let's take a step back and look at Rideau in greater context. In Rideau, only 3 of the 12 seated jurors had even seen that confession, and all agreed they would set it aside. In Rideau, only 65% of the veneer had seen the confession. Here, of course, we have nearly 100% of the veneer seeing the publicity. And in Rideau, of course, the confessions came into evidence. Here we have a situation where, and let me back up, let me expand on that. In Rideau, there were 3 confessions. 2 of them actually came into evidence. So at the end of the day, the jurors who decided Rideau's fate didn't hear anything that they, in pretrial publicity, that they weren't going to get in the context of the adversary system later at trial. In this case, not only do we have a much higher percentage of the veneer exposed to the publicity, but we have publicity in this case that covers inadmissible evidence, evidence that didn't exist, evidence that was ruled inadmissible, things like the Attorney General's the state's statement that the conviction was certain, they had a rock-solid winner, statements like articles about defense counsel believing his client was guilty, articles about evidence that had been specifically ruled inadmissible, articles covering evidence that didn't even exist. We have a situation here, we had those billboards placed outside on the freeway with a picture of Scott Peterson asking prospective jurors to vote man or monster for the telephone number.
Mr. Gardner, in light of that extensive publicity, where could the case have been tried?
I think that question really calls into question, Your Honor, two different concepts. One is recognition rate and one is prejudgment rate. I think that extent of publicity probably would have happened in any county in California. I think that's true. And that's the recognition rate. The recognition rate of this case was always going to be high no matter where the case was transferred. But what's important to keep in mind, not so much as recognition, is prejudgment rate. And the prejudgment rate, as the data showed in some of the pretrial motions, the prejudgment rate in Los Angeles and some of the larger counties was significantly lower than the prejudgment rate in Stanislaus, where the case was originally set. I think prejudgment rate is important, and I think what I'll call the set-aside rate. Murphy versus Florida talks about the number of jurors willing to express a disqualifying prejudice. I call that the set-aside rate. How many jurors refuse to set aside the views they formed? And Los Angeles had the second lowest set-aside rate. You want a low set-aside rate. You want jurors that are willing to set aside their views. So would the recognition rate have been high in all counties? Yes. Would the prejudgment rate have been as high? No. Would the set-aside rate have been different? Yes. And I think that's why in this case a second change of venue was appropriate.
Well, so Mr. Gardner, let me ask you, are you urging that we should articulate a rule that says Okay? In deciding where to change venue to, the court is obligated to pick the lowest of those rates.
No, I mean, that's a perfectly fine rule, but I don't think you need to set that rule. All I'm saying is that the data from San Mateo, where this case was tried, shows that a fair trial couldn't have been had there. A presumption of prejudice is appropriate. Justice Liu's question, as I understood it, was directed at, well, maybe there's no other better place to do this. And if so, maybe we really don't have a choice. And my point is, I think we did have a choice. I think there were lower rates. That doesn't mean that you necessarily have to transfer there, but at least it undercuts the argument where the judge throws up his hands and says, we can't, the percentages are the same everywhere, so we might as well do it here. It's that inference that's inappropriate because there are, in fact, jurisdictions where there is a lower prejudgment rate and a different set-aside rate.
I take your point. It seems to me, however, to be a subtle distinction, because if we agree with your position that because there were other venues, and I appreciate your giving this answer in response to Justice Liu's very fine question, but I'm concerned as to how that rule would be articulated if we dispose of the there's no better place to try question by relying on your assertion that there might have been other better places to try. Don't we begin to move in the direction of the court must simply select that venue that has the lowest difficult rates?
I don't think so, Your Honor, and I guess here's why. Let's say that the prejudgment rate in San Mateo was 30%, and the prejudgment rate in Los Angeles was 27%. Would I be arguing that the error here is in the failure to transfer to a jurisdiction like LA? The answer is no. A predicate for any of this and the presumed prejudice analysis takes this into account, is that in fact the nature of the publicity in the smaller county is such that a presumption of prejudice is appropriate. Now, at some point, I suppose Your Honor could come up with a case where the presumption of prejudice, the nature of the prejudice is such that we would say a presumption of prejudice is appropriate, but that every county would have the same presumption of prejudice because the nature and extent in every county would be the same, the prejudgment rate would be the same, the set-aside rate would be the same. If that were the case, we would be faced, I think, with a terribly interesting academic question, and that is, if you couldn't get a fair trial anywhere, must you still have the trial, or is the answer possibly to grant a continuance until the publicity has died down and you can get a fair trial at least somewhere? That is an interesting question.
Does it matter at all, counsel, that the surveys were conducted about a year before, if I remember correctly, Peterson filed his second change of venue motion?
Yes, Your Honor, I think that's right.
So, I mean, just talk a little bit through what the proper evidence really should be in a decision like this and how close to the change of venue should the surveys be conducted?
Well, to the extent the change of venue is based on surveys, they should be as close as possible. But remember, this change of venue wasn't primarily based on the surveys, Your Honor. It was based on the actual hard results of the voir dire, of the veneer. So by the time defense counsel brought his change of venue motion, 1,000 people had filled out jury questionnaires. Nearly the entire provisional jury had been qualified. 66 of the 76 had already been qualified. So as interesting as the surveys may be that were taken a year earlier and compared LA and Stanislaus, what was far more important in terms of, I believe, this court's focus in evaluating the change of venue motion is to look actually at the veneer that was in fact in court answering questions. So I agree with you. To the extent a venue motion is indeed based on surveys, they should be as close to the venue motion in time as possible. But this second venue motion was not based primarily on those surveys. I would like, unless there are other questions, of course, I'd like to reserve the remainder of my time for rebuttal.
Yes, Mr. Gardner, you'll have 10 minutes.
Thank you, Your Honor.
Ms. Provenzano. We can't hear you. Oh, I'm sorry. Go ahead.
Madam Chief Justice, and may it please the court. Donna Provenzano appearing on behalf of respondent, the people, including two people who are no longer with us, Laci and Connor Peterson. Your Honors, the gravamen of this appeal is appellant's contention that he was denied a fair trial. Suffice it to say, respondent could not disagree with him more. And before I address some of the points that opposing counsel has discussed with the court today, respondent would like to clarify a couple of things about the trial, in this case, as it concerns this appeal. First, the prosecution marshaled and presented a mountain of evidence that pointed the finger of guilt squarely at Scott Peterson as the murderer of his wife and their child. There is no contention in this appeal that that quantum of evidence was legally insufficient, because it wasn't. Second, with respect to jurors in this case, there is no credible claim in this appeal that any one of the 12 jurors that heard that evidence was anything other than fair and impartial. The 12 citizens of San Mateo County who were carefully selected for this case swore an oath, Your Honors, to be fair to Scott Peterson, to the people as well. And the record demonstrates that the jurors, each and every one of them, kept that promise. Now, with respect to the issues that were discussed today, respondent will address them in the order that opposing counsel has raised them, beginning with jury selection. With respect to the trial court in this case, it is clear from the record that by virtue of this trial judge's neutrality and his extensive experience in presiding over capital murder trials, that he correctly understood the governing legal standard to be applied under wit. And it is respondent's contention that the trial judge applied that standard correctly when he dismissed for cause the 13 prospective jurors that appellant has identified in connection with his first claim. So much so, Your Honors, that even appellant's trial counsel, as we noted in our brief, observed that the trial judge in this case had exercised, as counsel called it, Herculean efforts to get a fair jury panel. And so, with respect to the respective questionnaires of the 13 jurors, prospective jurors identified today, it is respondent's position that each and every one of them provided a sufficient basis for the trial judge to excuse them for cause under the wit standard. Now, recognizing that this court may disagree with respondent about any one of those, and should that be the case, respondent likewise acknowledges that this court has made abundantly clear since the time that the parties have filed our briefs in this case, that if there is even one erroneous excusal under wit, the remedy is to reverse the death judgment. And in fact, as recently as last year, in this court's decision in Armstrong, People versus Armstrong, the court said, and I quote, "The rule is not ours to revisit," unquote. And so respondent wishes the court to know that we understand that if that were to come to pass, and this court would reverse the death judgment based on an erroneous excusal under wit, that this court is compelled to do so under the authority of the United States Supreme Court in Gray versus Mississippi. In recognizing that, respondent does not intend to pursue that point with the court today, but we stand on the arguments that we made in our brief. And so with that, I will turn to the issue of whether or not a reversal of the death judgment under wit compels the reversal of the guilt verdicts or the special circumstance finding. And opposing counsel is correct. Respondent believes that this question under the Eighth Amendment has been answered by none other than the United States Supreme Court in wit, which made very clear that erroneous excusal under that standard is governed by the Sixth Amendment, not the Eighth Amendment. And the very case that's driving this train, if you will, Your Honors, on this first claim, Gray versus Mississippi, there is no mention of reversing the guilt phase verdicts. And this court in Armstrong last year made clear that there is no reversal of the guilt verdicts if there's an erroneous excusal for cause under wit. And so respondents' view is this question has been soundly answered by this court and the United States Supreme Court. With respect to, I'm moving on, unless the court has questions, to the boat demonstration. Appellant concerns, obviously, about the trial court's condition that the prosecution be present for a second attempt at a demonstration that would be reliable enough for the trial judge to put before the jury. And it is our position that that was a reasonable condition that balanced the interests of the parties. The boat, there was one boat. It was appellant's boat. It was a critical piece of evidence, and it was the prosecution's burden to prove this case beyond a reasonable doubt. To suggest that the prosecution could not observe what happened to a critical piece of evidence when it was out on the bay carries no water, no pun intended. And to understand that to be exculpatory, the demonstration for the defense necessarily would have had the boat take on water and capsize or sink. So to suggest that the prosecution had no right to be there, we believe is wrong. And we believe that based on the record, the trial court was doing its best parameters to the defense that would allow the court to admit the demonstration. And so what happened was the court made this offer to the defense, having rejected what was clearly an unreliable experiment. And appellant's trial counsel said, I'll talk to my client. And then he came back and said essentially to the trial judge, no, thank you. And so it was appellant's way or the highway. That's the bottom line. But it's our view that the trial court exercised reasonable discretion in trying to facilitate admission of an experiment. And so there was no incursion, Your Honors, under the Sixth Amendment with respect to that condition. And appellant made a choice. And maybe now, buyer's remorse, he wishes he didn't make that choice. But he did. And we believe that the trial judge was correct in terms of establishing that condition, among others. With respect to the juror experiment, we believe that this was just a critical examination of the evidence. And perhaps the best barometer of whether that is in fact true is to look at this court's decision in Collins. And we cited that case in our brief. And to briefly summarize what happened there, one of the jurors, the issue was the trajectory, the downward trajectory of a bullet that struck the victim. And so one of the jurors, very enterprisingly, went home and worked out height variations on his computer at home to try to figure out what that trajectory might have been. And so he did that, came in to deliberations the next day, did not tell his fellow jurors that he had conducted this experiment, and then he got a piece of string and a compass and started mapping out possible angles with his fellow jurors. This court determined that that was a proper examination of the evidence. And this case is no different. As a matter of fact, what the jurors did is not nearly as manipulating, if you will, as what happened in Collins. And in this case, when these two jurors, and I believe it was two jurors, got into the boat, there was no objection, and that was because the spatial considerations of appellant's boat, that was an issue in the case. And so all of the parties were present. The trial court was present when this happened. And then the jurors started to manipulate the boat by moving it or shaking it. And at that point, there was an objection. And at that point, the trial court gave the jurors an admonition, which is so commonsensical. And that is this, that when a boat, the boat that they were looking at, appellant's boat, was on a trailer. It was stationed on a trailer. And the trial judge told the jurors, whatever happens on a trailer with the stability of this boat is going to be a far cry from what happens on the water, the open water on the bay. And it is respondents' view that that admonition was entirely sufficient. And even beyond that, Your Honors, as the trial judge pointed out, that experiment or that manipulation may have inured to appellant's benefit, because it's entirely possible that those jurors might have felt that there was a fair amount of give and take, stability-wise, while it was sitting on the trailer. And if they made that assumption, then they could certainly assume that it was going to be even less stable on the water. And so all told on this issue, we believe that the trial judge was correct in the conditions it imposed on a second experiment if it were to be conducted, and correct in the way that it addressed the jurors' manipulation of a critical piece of evidence in this case. And unless the court has questions on that, I will move to the issue of venue. The fundamental flaw, well, let me back up for a moment. What appellant was attempting to do was to move venue, move the trial, in this case, to a third county. It had already been moved from Stanislaus to San Mateo County. And at the time that appellant brought that second venue transfer motion, it was clear that the trial court had already qualified, I believe, 66 jurors, prospective jurors, for this trial. Appellant did not challenge for cause any one of those 66 at the time that he made this motion. And I think that's a very valid point. Beyond the fact that once this jury was seated and sworn, he had passed 4 times on this jury. And it's respondents' view that that is very probative information. But if I may, there was a fundamental flaw in appellant's motion, and that is this. He did not show the trial court that he would have fared any better in another jurisdiction. And not only on the issue of recognition, and it was clear, and I should say too, the prosecution's expert, Dr. Evison, who conducted the surveys and who supported the prosecution's opposition, his numbers differ from those that appellant cited today. For example, in terms of recognition rates, Los Angeles County was at least 2 percentage points higher than it was in San Mateo County. But appellant is focusing on prejudgment. And Dr. Evson, with his surveys that, as Justice Cuellar pointed out, were done a year in advance. He also, though, looked at the questionnaires, a sample of questionnaires from the veneer. And based on that, he determined that the prejudgment rate would actually be higher by about a point or a little more than a point in Los Angeles County than it was in San Mateo County. So in other words, Your Honor, there is no evidence appellant presented that he would have fared better not just on recognition and publicity, but also on prejudgment. And the other point, to Justice Cuellar's point about conducting the surveys in a certain time frame, respondent would suggest that conducting it a year ahead of the time that the second motion was made would be closer in time to when the bulk, if you will, of the publicity actually occurred in this case. Because the experts, I believe, agreed that there was an ebb and flow to the coverage in this case. And most of the coverage, understandably, occurred when Laci went missing. And so by the time we got to trial, there had been basically an ebb in the publicity. And so therefore, my suggestion, Your Honors, is that those surveys were highly probative when the publicity was at its highest. And as the trial judge, I think, said here, the only place that this case could have gone where no one would have heard about it was Mars. And that was true. Everyone had heard about this case. But just one more note about prejudgment. Even if we take appellant's numbers as they are higher than what the prosecution's experts said, that doesn't account for whether or not those would agree to set aside their views, even if they had prejudged appellant. And so, to summarize, we believe that the court's denial, the trial court's denial of the motion in this case was appropriate, and it was correct. And I do want to, though, backtrack a little bit and talk about presumed prejudice. The United States Supreme Court's decision in Skilling laid out the Rideau, Shepard, and Estes cases as examples of when publicity gets to a certain extent that's so pervasive that it actually corrupts the trial atmosphere. And looking at this record, Your Honors, respondent feels strongly that yes, there was a lot of publicity. However, it stopped the courtroom doors. In fact, it stopped at the courthouse doors because the presiding justice of the San Mateo County Court, along with the trial judge in this case, took great pains to keep this trial from turning into what the U.S. Supreme Court has called a carnival atmosphere. That is when prejudice is presumed. That is what happened in Rideau, in Estes, in Shepard. That did not happen here. And so for those reasons, Your Honor, respondent maintains that the trial judge was correct in his denial of the venue motion. So unless the court has any questions on that or any other matter, respondent asks this court to affirm the judgment, and we submit the matter to the court. Thank you.
Thank you, Ms. Provenzano. Mr. Gardner?
Thank you, Your Honors. A couple of points on each of the three issues, Your Honor. Let me start with the Wainwright, the Witherspoon, and the Witt issue. I don't want to spend a great deal of time on the guilt phase aspect of this, but counsel suggests, I think, that Gray is the case that, quote, drives this train. And she notes correctly that in Gray versus Mississippi, there was no suggestion that the guilt phase could be reversed. But as I pointed out at page 110 of my opening brief, in footnote 32, the petitioner in Gray versus Mississippi did not ask for reversal of the guilt phase. So the suggestion that Gray versus Mississippi somehow resolves this issue when the petitioner in Gray versus Mississippi never raised the issue goes counter to everything this court has ever said about cases not being authority for propositions not presented. That proposition was not presented in Gray versus Mississippi. My suspicion is that the reason it wasn't presented in Gray and the reason it wasn't presented in Adams versus Texas is because the Sixth Amendment on which it was based, the Sixth Amendment argument, had been rejected in Witherspoon. But this is a very different argument. This is the Eighth Amendment argument. My colleague suggests it's not yours to revisit. I'm not asking anyone to revisit it. My position is that it needs to be visited for the first time. So that's the Witherspoon issue. Let me talk for a moment about the boat demonstration rulings. Counsel did not talk about Prince versus Superior Court, and that directly involves our issue. And Prince says that when evidence can be retested, you cannot hinge defense testing on the presence of the prosecutor. The prosecutor under the adversary system does not get a seat at the defense table. To the extent my colleague is suggesting that, well, the boat might capsize and some evidence might be lost, I note that the state harbored no such concern in People versus Roller, a case that the state cites and relies on in its brief, where the state itself performed 8 capsize experiments with a similar boat without the defense present. So that concern seems to me to be extremely variable. In terms of the jury experiment, my colleague relies on Collins and has the facts pretty much right in Collins, except for one point. And that is when the juror did his experiment, my colleague doesn't mention that, in fact, there was a coroner that testified. And the coroner testified about the trajectory of the wound. He said it was backwards to forwards, it was left to right, and it was downward. And what the juror did was he took those parameters and he did an experiment with those parameters. In other words, the experiment he did was within, quote, the lines of offered testimony, end quote. That's the rule. We don't have that here. There was no testimony about the stability of a boat on a trailer and how it compared to the stability of a boat in the open water. That was the inference jurors were trying to draw. And there was no testimony about that inference. That inference was not within the lines of offered testimony. My colleague from the Attorney General's office says that the court gave a commonsensical jury admonition. Actually, I agree. What the court said was, quote, it was not a particularly strong admonition. What the court said was, quote, stability is not the same on a trailer as it is on the water, end quote. That is common sense. But it's something that all 12 jurors already knew. They were trying to draw an inference from stability on the trailer in the garage, to an inference as to what that would mean. And that inference was not within the lines of offered evidence, and the jury admonition told them nothing they didn't already know. With respect to venue, I'll make 3 points, Your Honor. Counsel talks about the fact that a presumed prejudice conclusion requires a carnival atmosphere. And she's certainly right that there was a carnival atmosphere in the Shepard case, and perhaps Estes, but not in Rideau, and not in this court's decision in People versus Williams, and not in this court's decision in People versus Tidwell. So while, yes, a carnival atmosphere is relevant to the calculus, it is not dispositive of the calculus. Otherwise, Rideau, Williams, and Tidwell would have reached different results. Counsel talked about the set-aside rate, and I want to be clear about this. The number of jurors that refused, the percentage of jurors in the veneer here that refused to set aside their views is higher than any case this court has ever upheld. 46% of the veneer had reached a decision. Of that, almost all of them, their view was that Scott Peterson was guilty, and half of them refused to set aside their view. Murphy versus Florida, the Supreme Court says that when a significant percentage of the veneer has expressed a disqualifying prejudice, we need to presume prejudice. We can no longer rely on a robust voir dire to achieve a fair jury, and that's exactly what we have here. Counsel points out, and this is my last point, Your Honors, counsel points out that the 12 citizens who were tried to this case, who agreed to try this case and who were seated as jurors, agreed to be fair. And they did, just as they did in Rideau, just as they did in People versus Williams, just as they did in People versus Tidwell, in all these cases. What the point misses, I think, is the underlying premise of the presumed prejudice calculus. When the community has been saturated with prejudicial publicity, we cannot rely on voir dire to obtain a fair jury. That's why in Rideau the court said we're going to presume prejudice. We're not going to look and see a particularized discussion of the voir dire to see that all 12 jurors said they would be fair. Jurors said that, and they say it in good faith. I'm not suggesting for a moment that they got seated on that jury with an intent to violate that oath. But when the community is saturated, jurors may not recognize prejudices that have been caused. Jurors may not be aware of the prejudice. They may genuinely, when they agree to put aside their views, they may genuinely believe it. It may be fleeting. And of course, those jurors are going to return to the community that's been saturated with that publicity, knowing that they may reach an unpopular verdict. And what will that mean? And that's certainly the case here. I mean, let's recall the facts. This was a case where when Mr. Peterson was arrested, there was a lynch mob outside the jail, and the sheriff indicated that his concern was that Mr. Peterson didn't get lynched. And when the guilt phase verdict was ready to be announced, there were thousands of spectators in the courthouse square cheering for the guilty verdict, as there were thousands a few days later when the penalty verdict. So this is a case where jurors were very much aware that the community had not only been saturated with publicity, but that they expected a certain verdict. With that, Your Honors, unless there's any questions about any of the issues, I'm happy to submit the case.
Thank you, Mr. Gardner, and thank you, Ms. Provenzano. The matter is submitted.
Thank you, Your Honors.
Calling the matter of the people versus on the Duong. And when you're ready, Ms. Sabah, press.
May it please the court, Deborah Saba Press on behalf of Mr. Duong. The police seized the Ford in this case for one reason. They were investigating Mr. Duong for the crimes charged in this case. Because the police chose not to obtain a warrant, that impound was presumptively unreasonable, and the onus was on the government to demonstrate that at least one of the specifically delineated exceptions to the warrant requirement was applicable. It could not do so under these circumstances. There were no legitimate community caretaking concerns, the search was not a valid search incident to arrest, and no other exigencies that would have justified a warrantless search were present. The bottom line is that the seizure of the Ford was a subterfuge for investigation and was therefore unreasonable under the Fourth Amendment. The trial court's ruling, the trial court starts by making a general statement about the purposes of impounds. And he says that the purpose of an impound is to facilitate